Good morning, good morning. I'm told to speak loud and clear, so can everyone hear me all the way in the back? All right, very good. Yes, indeed. My name is Kathleen Wright. I'm the chair of the California Board of Accountancy's Enforcement Program Oversight Committee, and I'd like to call the meeting to order. First thing is to take roll, so Sachi, can you start that process for us, please?
Sachi Howard.
Alicia Burhow.
Kathleen Wright. George
Dunaway.
Karen Hines.
Thank you. With that, we have a quorum. We have a quorum. All right, very good. Moving on to the agenda then. Agenda item number 1 is approval of the minutes of the September 15th, 2016 Enforcement Program Oversight Committee meeting, and would any member like to make a motion to accept the minutes? Thank you, Carrie Ann. Anyone second that motion?
Second.
Very good. Any public comment? Thank you. I will now call for the vote. Rebecca?
Kathleen Wright.
Yes?
Alicia Burhow.
Yes.
George Familette.
Yes.
Carrie Ann Hines.
Yes.
Soshi Leon.
Abstain. All right, the motion carries? The motion carries. Thank you. Agenda item number 2 is a discussion of the revised schedule for the disciplinary guidelines and model orders. And Dominic, Mr. Franzella, is going to tell us a little bit about what this agenda item is all about.
Thank you. Good morning. So beginning in March of this year, the CBA began its triennial review of the disciplinary guidelines. So in an effort to keep members informed, staff developed a revision schedule to show progress and expectations regarding this process. And as the CBA has progressed with this evaluation, staff have made updates to the schedule. The most current version of the schedule can be found beginning on the bottom of page 1 and continuing on to the top of page 2. For this meeting, the CBA will be considering an additional change to the guidelines and also whether it wishes to initiate the rulemaking process. If the CBA were to initiate the rulemaking process, staff anticipate a public hearing on the regulations would take place in either May or July. And there's no specific action required from the members on this item, and staff obviously have no recommendation, but I'm happy to turn it back over to the chair and answer any question members may have.
No questions? No questions? Yes.
It's okay. So we are on schedule. Everything's on track. We're good at this point.
Yeah.
Okay. Thank you for that succinct answer.
Yes, essentially, the schedule was modified is what happened, but we're on track with the schedule, as I understand. All right, very good. Well, thank you. Thank you very much. Agenda item number 3 is a discussion and possible action to initiate a rulemaking to amend the disciplinary guidelines and model orders and CBA regulations section 99.1 rehabilitation criteria. And Dominic, you're going to tell us a little bit more about this. It's coming from another committee and so forth.
Absolutely. So for this meeting, the CBA is being asked to review the proposed changes to the regulations and possibly direct staff to initiate a rulemaking process. This committee has been considering various changes to the guidelines and the rehabilitation criteria for much of this year. And on the bottom of page 1 and top of page 2, we've highlighted and outlined the various modifications the CBA has been considering. At the last meeting in September, the CBA was asked to consider a proposal from CalCPA on a possible modification to the minimum penalty outlined in the guideline associated with violations of Business and Professions Code, Section 5100, Subdivision L. But at the request of CalCPA, discussion on this topic was deferred to provide some additional time to engage in discussions with stakeholders. But also at the September meeting, the CBA adopted a CPC recommendation to have the EPOC consider a reduction in the minimum penalty associated with criminal convictions. So first, with the CalCPA proposal, staff did facilitate a meeting as requested with stakeholders. Staff has since been informed that Cal CPA is no longer seeking to have the CBA consider a proposal at this time. So, as for a reduction in penalty associated with the minimum guidelines for violations of Section 5100A, as noted in the materials, the CBA has been evaluating criminal convictions associated with drugs and alcohol for a couple of meetings. As requested by the CBA, staff have included in the EPOC's materials the opportunity to discuss a reduction in the minimum penalty associated with violations of 5100A. So on the top of page 3 of your materials, staff have included the existing minimum and maximum penalties for violations of Section 5100A. The guidelines set the minimum penalty for convictions substantially related to the qualifications, functions, and duties of a CPA for felony convictions and multiple misdemeanor convictions presently at revocation stayed, actual suspension of 120 days, and 3 years probation. As part of the CPC's discussions on criminal convictions related to drugs and alcohol at the September meeting, it was requested that the EPOC consider a possible modification to the penalty, and the CPC recommended a minimum penalty to be revised to a suspension stayed, 1 year probation. Staff have noted that with suspension, generally a set number of days is required and should be identified. So therefore, staff have proposed in the materials that the minimum, if the minimum penalty is modified, that the suspension period would be set at 120 days. This is consistent with the present actual suspension period associated with the existing minimum guidelines. As the CBA considers whether the further evaluation of criminal convictions is necessary, I would like to note that the proposed modification, as we discussed at the CPC meeting, as presently contemplated in the guidelines, would be applicable as a starting point for all types and natures of criminal convictions. Staff have prepared amendments to the necessary regulation sections as well, which include CBA Regulations 98 and 99.1, to provide the CBA the ability to initiate a rulemaking at this meeting to amend the guidelines and the rehabilitation criteria. These modifications are found in attachments 2 and 3. So if the CBA supports the changes to the minimum penalty for Section 5100A, staff recommend the following motion to initiate the rulemaking, which is actually on page 4 of your item. We've been advised that a specific motion be put into the record, and this would be the CBA approved the regulatory text in the guidelines and CBA regulations sections 98 and 99.1. Direct staff to submit the text to the Director of the Department of Consumer Affairs and Housing and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the Executive Officer to take all necessary steps to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. At this point, I'd like to turn discussions back over to the Chair, and I'm happy to answer any questions members may have.
Okay, thank you, Dominic. Is there any discussion?
Do we need to make a motion? Is that?
That was going to come next, but yes.
Before you make a motion, I'd like to speak to this item. So with respect to the change being proposed by the CPC committee, on page 31, where the proposal is to revise the minimum penalty that's currently 3 years probation for a crime, a substantially related crime, to 1 year. Part of the calculation that goes into determining whether something is a minimum penalty is determining how much work is needed to properly monitor someone on probation, and if a violation occurs, to take appropriate action before you lose jurisdiction. Because if the time frame is too short and you don't file your accusation before the time for probation runs, you lose jurisdiction to take that person out of practice. In addition, suspension stayed versus revocation stayed. When you move to suspension stayed, if there's a violation of probation, then the worst penalty you can seek is suspension. So if the person commits another crime while they're on probation, the worst thing you could do for a violation of probation would be to suspend the license. Or you would have to go out and file a brand new accusation charge them with the new violation, which kind of defeats the purpose of putting someone on probation. The purpose of putting them on probation is to ensure that you're able to take someone out of practice more quickly than you would if you had to build a brand new case and start from the clear and convincing evidence standard for an accusation. So there are some concerns regarding how long it's going to take you to investigate a violation of probation if it comes to your attention and they only have a 1-year probation. And I think Mr. Sani's here. He may be able to speak to the challenges that may occur if you have a 1-year probation, because it's not just your staff's investigation time that would take to investigate a violation, but then you have to turn it over to the Attorney General's office to file charges. And I don't know what their time frame is, so there's a risk at lowering it to such a low number that you may lose jurisdiction in some of your cases.
So when you say, oh, sorry.
Carl?
Yes, one of the standard terms that exists in most of the probation documents is that cost recovery needs to be paid within 6 months of the termination of probation. And the reason why that requirement exists, that it be paid early before the actual end of probation, is mechanically the process of identifying a failure to comply with, for example, cost recovery, requires that it be validated by the staff of the Board of Accountancy, make sure that the money was not misdirected somehow. And that process takes several weeks. And then it's referred to the Attorney General's office if, in fact, they have confirmed that the person has failed to pay cost recovery. And typically, the Attorney General's office gives itself about 90 days in order to bring an action, what we would call a petition to revoke probation. In a petition to revoke probation, the burden of proof is much lower in order to establish that there's been a violation rather than the standard for an accusation, which is clear and convincing evidence. So that is a pragmatic function. So if you have a 1-year probationary period, suspension stayed, that means that effectively, barring some exigent case, you're really putting the person on supervision or real close monitoring for about 6 months, because it's going to take violations that occur 6 months in is going to take several months before it actually comes to fruition for the filing of a document. And a petition to revoke probation has to be filed prior to the termination of probation. Otherwise, we do, in fact, lose jurisdiction. So that's one consideration. The other kind of factual matter is, as a practical matter, the minimum terms that are in the disciplinary guidelines are, in my experience, the common terms that are employed by administrative law judges. So if an administrative law judge finds that there's in fact been a violation of some professional conduct standard, then barring something that would take it out of the realm of the common violation, whether it be a financial dishonesty, whatever it may be, it's going to get those minimum terms of probation. If it's more severe, the more likely consequence would be then that you'd probably be going for not so much an extended period of probation, but probably revocation. So it takes a little bit, it resets the standard that administrative law judges will look to in imposing discipline in the cases that go to hearing. The only other kind of factual issue is, I think, distinguishing various types of offenses with different types of standards for convictions is, in theory, feasible, but sometimes convictions don't reflect, that is, the crime that a person pleads to does not reflect the crime that was initially charged. So a person might be charged with embezzlement, but plead guilty to unauthorized computer access. And if we bring the claim based on unauthorized computer access, you might have one set of criteria that would apply, even if what was really going on was attempted embezzlement. So those are problems that we would have to work through. I'm not saying that they're not workable, but there are sort of factual issues that will be confronted by the Attorney General's office in evaluating the appropriate charges to bring in an accusation when there's been a criminal conviction. I don't know if that's responsive.
Okay, I thank both of you for those comments, and forgive my ignorance, but I do have a question.
Okay.
With respect to the issues that you're bringing up, the person has already been placed on probation, which I'm assuming means that due process has been applied to whatever the original charge was, meaning that they've gone through whatever procedural process related to the original complaint that was received by CBA. Okay, so I'm assuming that that's been completed. So are we talking about then violations of probation, which would be a new offense, quote?
Well, I was
No.
kind of listening out of one ear while I was scanning the agenda item. There was sort of two topics under discussion. One is what happens when you're on probation, and certainly due process has been meted out at that point. There's been an opportunity for either a hearing or a settlement.
Right.
The other issue was just convictions in general and how are they handled at the pleading stage. So before you even get to the probation stage, you're dealing with how do you formulate an accusation based on a conviction. And I'm suggesting that it's not always as straightforward as it might appear to be in theory.
So, for instance, we get a criminal offender record information hit that someone's been arrested and then they were later convicted of arson or a sex offense. I'm not going into the dishonesty ones because that can be charged differently. So other types of crimes besides a dishonesty crime. The proposal before you would be that you would start with a 1-year probation as opposed to 3 years. And I think what my concern is that 1 year is really not enough time to monitor someone for a serious crime that's related to the practice. And if there's a violation, my concern would be that you might lose jurisdiction over your cases before you're able to actually make sure that person's safe to practice. And that's why a 1-year probation is unheard of. I've never seen a 1-year probation for a criminal substantially related crime as a starting point for discussing what penalty should be imposed. Because the more complex the case, the more investigation, the more work that needs to be done, the greater amount of probation you need. So the 1-year probation I've only seen for a board where it's a simple violation like failure to have a fictitious name permit. Fictitious name permit, do you have one or don't you? It's very simple. And that's a 1-year probation. But crimes, typically 3 years is a very common starting point for non-healing arts boards. The healing arts boards have a 5-year minimum for substantially related crimes. My physician assistant board clients is 5. My contractor state license board clients' minimum starting point is 3, similar to the one you currently have.
But wouldn't this agenda item, similar to the prior one which deals with suspension in 120 days, provide the board with the flexibility to impose whatever probationary period they wanted above 1 year? So if in due course it was apparent that, the issue was a felony, perhaps unrelated to dishonesty, but nonetheless a felony, and the board were to choose 3-year probation under this revised standard, we would have that option, would we not?
Yes.
That was my general understanding of the change discussed in more detail in a prior meeting on the 120 days, is that imposing these significant issues or significant remedies, so to speak, on every offense and not giving the board the opportunity to evaluate the seriousness of the offense was the objection, and that the cure or the remedy was on the 120 days, as Dominic has described, to eliminate, to reduce the minimum, but give the board the flexibility to retain whatever maximum standard they felt appropriate. Isn't that also what we're considering here?
Yes, but the problem is, in our experience, the administrative law judges and people that are negotiating settlement agreements start at the minimum, and then they go up and down from there. So if you got a proposed decision and it imposed a 1 year, and you said, well, I think it should be higher, you'd have to reject that decision and rewrite it. So that would be a more of a workload issue for you. Whereas if it started with 3 years in a proposed decision and you said, that's too high, you could, under current law, adopt that decision and reduce it to 1 year or 2 years. So you wouldn't have to rewrite the decision. That's the difference when you start with a low number and you want to go higher in a proposed decision. The Administrative Procedure Act requires you to rewrite the decision. And that's more work for you.
No, I understand, and that's a good point, and I wasn't fully cognizant of the APA and how it dealt with these items. But I just do want to clarify one thing, so that I can make my own decision regarding the vote, and that is, if a decision a proposed decision from an ALJ came before the board where it was no more than failure to properly register the name of their corporation under whatever the guidelines are for registering a fictitious name, the less significant offense that you used as an example a moment ago, then the ALJ's decision would use the minimum, which would be 3 years if we don't change it. And then we would have to be made aware of that as a member of the board,
right,
to then be able to take an action to reduce it to something less than the 3 years if we felt that was appropriate. I'm not sure we always realized that at the time that we review these decisions.
We always inform the board of their options regarding what they can do with the decision, but I think that for this case, because of crimes, when you make a change to the guidelines, it's regulatory. So you have to have a good public policy reason for lowering it to 1 year. And what I don't hear is why we're doing it. That is one of the reasons you have regulations. You have to explain the purpose and what the rationale is behind it.
Right.
So if you're going to lower it to 1 year, it should be that it would be easier for staff. Well, it's not easier for staff, in my opinion, or your process currently to lower it to 1 year if it's a complex matter. 1 year, I'm not sure what the rationale is behind it, so we'd have to explain to the Office of Administrative Law why we're lowering it to 1 year and why 3 years is, 1 year is more protective of the public versus 3.
Okay. Dominic, do you want to comment on that? I do have a comment, but do you want to comment on that, on Christie's question?
I'll wait for whatever comment you have.
Okay. My only comment would be the example that you suggested initially and I just repeated, which is that if it's a lesser offense and it's a misdemeanor, now granted this does say multiple misdemeanor convictions,
Right.
But there are multiple misdemeanors that would be de minimis in the eyes of many. And in that case, would the ALJ even have the flexibility of reducing this 3-year period to a lesser term? The board would have that flexibility if we realize it, but the ALJ would not. Is that a correct summary?
Well, the administrative law judge does have flexibility to lower it, and usually what they do, and it states in the guidelines, is that it's a guideline and that aggravating and mitigating circumstances may be considered, and a mitigating circumstance lowers the penalty. And judges frequently will discuss that in their decisions, and they will weigh and balance aggravating and mitigating circumstances, and in the mitigating circumstances, lower the penalty. So you will get decisions where the penalty is below the minimum because of some really significant rehabilitation evidence, maybe the passage of time plays into that issue. And that's what's currently in place, that they have that flexibility. And then again, your decision, you could still further lower that penalty if you received it.
Okay. Carrie Ann?
One of the concerns in my short time of being here is that the decisions that we've been receiving, the stipulated settlements and some of the decisions that we've been receiving have been such that they don't seem to reflect either the administrative law judge's ability to consider a lesser penalty or, excuse me, where there has been a negotiated settlement that considers a lesser penalty. And what that means then is that we as a body have to spend more time going back to the prosecuting body to explain to us the rationale behind the administrative law judge's decision or behind the stipulated agreement. And then we have to spend time deciding, second-guessing the efforts of the parties in that negotiation. My understanding of why we were changing the rules, recommending a change in the rule, is for efficiency. It's to send a message that we want to see decisions that are better reflective of the circumstances around the crime that's being prosecuted. And so it's not that we're sending, the public policy rationale is not that we're sending a message that these crimes are not important or significant, but the intention is to send the message that we want to see decisions from administrative law judges or from, or stipulated agreements that really reflect the circumstances of each case and really reflect a penalty that has the public's interest, protection of the public at its core, rather than punishing the licensee for the crime that they committed. So I think there's some concern that by having this high threshold penalty, it sends a message that punishment is our primary motivation rather than protection of the public. And that's just what I've seen reflected, and by having that lower threshold, it feels like it opens the door for all the parties to be more cognizant and more deliberate about what the actual penalty is in the end.
Thank you, Carrie, and I personally agree with you. Dominic, can I ask you a question? Was this one, the change from 3 to 1 year, also part of the CPC's recommendation?
The probation period was a suggestion from the CPC.
Okay, so both of these, the 120 days and the 3 to 1 years, were both considered? No.
The 120-day, the CPC just said suspension stayed, didn't provide a date or a duration of time, but it's important that there is if we do move down this path, that there is some duration of time set at some minimum. That way the public and the licensee are clearly aware of what potential suspension may be. So
okay.
Staff looking to the existing minimum penalty that actually has an actual suspension of 120 days included in it, use that as kind of the base point for including it to this recommendation.
But the 3 to 1 year was a recommendation of the CPC?
It
Right.
was correct.
Okay, very good. Thank you.
Follow-up question. In terms of the number of cases we see, would you see a large number of cases be impacted by this in terms of either the stipulated agreements or decisions that have to go before the ALJ? In other words, is the majority of the case kind of what we'll call lesser offenses around the name or the example we've been doing here? Trying to get a sense for how big of a change in weighing the efficiency, I guess, of this board versus some other procedural efficiencies and difficulties that may be created.
I think if we were looking maybe 18 months ago or 2 years ago, this may have had a significant change because the board was seeing a lot of DUI, drug-related matters, as the primary and sole basis for the criminal conviction. In the matters I've seen recently, at least that I can think of off the top of my head, a lot of the criminal convictions we're dealing with also involve other crimes of dishonesty, embezzlement, and theft. So this would not be a standalone charge to which we could look at. Do I believe it'll have an impact? Yes, it will have some impact on what we do. I do believe that it has been articulated that this really just this is a board policy. It resets and where the floor is on what what the range of discipline is. If the board believes that a one-year probationary period is kind of where the floor can start, staff will use mitigation and aggravating penalties, rehabilitation, look at the nature of the violation. We do that now. We just start at a different point. Presently, we started a 3-year probationary period and a revocation. We've brought cases to the board that deviate from the guidelines on a number of bases, not generally on criminal convictions, but on other elements, but we would apply the same judgment. I don't have a personal opinion on this particular issue. I believe it's a board policy, and I'll implement it as this board sees fit. But I do believe the overall impact, at least as I've seen it presently, is a little bit lessened than it was maybe when I first started, because we were taking a lot of DUI cases at that particular time. This board has provided direction on various cases and how we should be handling certain cases, so I don't see as many coming. I haven't seen as many come before the board lately, and I believe the board has a good representation of a wide range of cases in their packet for this meeting, and there are criminal conviction cases in those matters, and they generally have other charges included in them as well. So I don't know, I can't give you a specific, it'll reduce, it's like 50% or do something to that effect, but it'll have an impact, but I'm not sure it's going to be as far-reaching potentially, at least in terms of where we start. But it's a board policy that I'll implement as it sees fit.
Okay, Patty, did you want to make a comment?
I'll defer to the member first.
You want to do, okay.
Since we're making a record for the OAL to support the change in policy, I want to acknowledge that we recognize the advisement that this creates a different, rubric within which we are going to be prosecuting these crimes in the future. And I think what we should make clear is that as a board, we're sending a message that we expect to see decisions back from stipulated agreements or decisions from administrative law judges that are much more reflective of the rationale behind imposing a certain penalty rather than it sort of relying upon the minimum penalties that are recommended by the law. So it will be an additional burden upon the staff, but if our goal is really to make sure that we are protecting the public, then the expectation is that we expect to see decisions that reflect that in them, and then we can go back and change those where we feel like they're not appropriate, as opposed to us having to evaluate the decisions much more frequently because we don't necessarily trust that they are fully addressing what our policies are and what our goals are.
Sachi?
I guess my concern is that I believe that the original intent was around crimes associated, triggered by alcohol, drug-related offenses. And now what we're seeing in front of us is for all crimes. And I don't know if that was the outcome of the CPC discussion in the last session, or it seems like we broadened the scope, the original intent of this recommendation. And if I would have preferred to see something that was still in scope, narrower in scope, that was reducing the probation period, but it was limited to only crimes related to drugs and alcohol. But I don't understand how it broadened. But that's my concern with this. It's
I think
broad.
Right, and I agree with you, but I think what happened is the amendment to 5100A is one section, and it applies to all of these crimes. I mean, it applies to all these offenses. It's procedural. It's the way the regulation is structured at the moment. Now that, I don't think, means that we can't change the regulation, yeah. But the motion that we have before us does not change the structure of the regulation. It just amends the existing language. And Dominic, correct me if I'm wrong.
The CPC did, that was a matter that was kind of brought to the CPC's attention, and they were aware of it, and they had recommended to make the change applicable across 5100A. They did not look to have the EPOC or the CBA consider a narrowing of 5100A to, or this reduction to just crimes involving alcohol and drugs. So it was contemplated, and a recommendation was differing from that.
So, I mean, this committee can choose to accept or reject the request for consideration by this committee and make a different recommendation.
Okay, so in summary then, it looks like we are considering the following questions, but let me ask one further question before we get to that part, and that is on Carrie Ann's recommendation, which is that explanation be included in these decisions regarding how the ALJ arrived at whatever probationary period they assigned. Would that be an amendment to our existing regulation, or would that simply be a procedural process that would be incorporated by staff?
I think the current guidelines already require that. The problem is we don't have a lot of control over what the judges do when they write these decisions. Some are better than others in explaining why they got to that penalty. With respect to stipulations, that's a procedural process that can be corrected internally. It doesn't need to be addressed in the disciplinary guidelines. And this amendment that's being proposed wouldn't address that issue.
No, I realize. No.
All it's doing is lowering the amount of time that you're monitoring somebody for a crime that they've committed. So that's the concern I have, is I'm not seeing why lowering the penalty would affect the concerns that have been raised.
Okay, yes.
Am I hearing correctly that your concern is that the administrative law judges are not adequately fulfilling their responsibility to make sure that their decisions are reflective of what the laws and regulations are? Because if we need to be concerned that administrative law judges are going to come to the wrong decision, or we have to really second guess what they're doing, then this isn't an issue for our regulations and our policies. This is an issue for us to take up with the body that oversees the administrative law judge. Right. And that's a greater danger to the public than what our regulations and our policies are. And that's something we should then really take up, because I don't think it's the best use of our time to have to second guess the ALJ decisions that are coming to us. That's not in the public's best interest, and it calls into question all of the decisions that come before us. So is that really what you're saying to us?
Well, it's happened, and I know the members know this, that we've had to take back a decision and rewrite the entire decision.
But the frequency is such that we need to
hold
off on...
I don't want to give a percentage, but it happens. And that's the check that you have on everything that's written. At the end of the day, this board is the ultimate arbiter as to what the penalties are in its decisions, whether it's by settlement or whether it's by default or whether it's by proposed decision. So if anything in any decision you feel is not adequately explained, if you think the penalty is not adequately explained, or if the facts are not correct, then your opportunity then is to take that decision up and rewrite that decision, and you have that option every single time that you have a proposed decision. One of the things that I was explaining is the benefit of a situation where you have a higher penalty that's being proposed in a proposed decision, but you like the way it's written, is that under the Administrative Procedure Act, you can just adopt the decision as your own and just simply reduce the penalty. But when you have a low penalty, which is, as Mr. Sani's explained, the judges tend to gravitate towards the minimum penalty number in a lot of their decisions. And the problem is, if that is a number that you're not comfortable with in a proposed decision and it's too low for the type of crime, perhaps it's a manslaughter case, perhaps it's an arson case, perhaps it's a case where you're concerned about the safety of the public and 1 year is not long enough, then you would have to reject that decision and rewrite it with the higher penalty in mind. because that's the way the Administrative Procedure Act law is written.
Okay.
So,
I would like to summarize this and let me know if I'm procedurally proceeding as I should. The issue with the administrative law judge, I think, is a very important one. I think it addresses an issue that is pervasive for every action that comes before the board and is not at this point on the agenda and an issue for this committee per se to deal with. And I think it's very important, Carrie Ann, and I think we should carry on this conversation. I just am concerned that it's getting outside the scope of what our committee is involved with. Having said that and registered that with Patty as an item for discussion, to Sachi's point, I would ask the committee the following. Sachi is of the if I misstate your comment, please let me know, is of the opinion that these reductions of the minimum penalty or the minimum probationary period should be specifically addressing certain offenses, and that the structure of our regulation, which is to have these reductions in probation be applied to every single offense that comes under that particular heading, which is much broader than the offenses that, as far as I remember, you are correct, were discussed, would mean then that this motion, if we agreed with that, this motion should be amended and then resubmitted to the board so that we can address the minimum time frame and vote on that modification as opposed to the one we have before us. Is that the direction that you want me to call for a vote?
well, you have to have a
determine whether we
motion,
want to amend
you have
it?
to have a motion and a second on whether to accept or reject the recommendation from the CPC first.
Okay.
And then if that one passes, depending on what it is, then we can know what to do from there. But
Okay.
I don't know what the will
Okay,
is.
so everybody understand what we're voting on? We're going to vote on what is on the agenda and what is being submitted. So let's do that.
So first decide whether you agree with the recommendation from the CPC to lower the minimum penalty to a 1-year, 120-day suspension stayed penalty.
Point of clarification, do we have an option of tabling it or sending it back for additional comments as opposed to adopting it or rejecting it immediately? Because I think the point that Sochi brings up is valid, and we are missing a couple of our board members, and I have some discomfort with passing, or rejecting this matter without, with such a small number of board members present. And I think that I don't know what the outcome of the vote is going to be, but I think this is a big issue for us, and we may need to have a bit more discussion about it.
I would have to agree with that. This is, I thought I knew where I was going to go with this from the very beginning, and now I'm kind of confused as to how I want to vote, because I totally take what you are saying into consideration, and I do believe we should be a check on the administrative law judges, because, they don't always, for the most part, being on this board now for 6 years, they do a really great job, and they're really good on a lot of these decisions, but I like being a check on them, and going back and looking at these cases, going, okay, wait, we need to go ahead and take a second look at this case. So I definitely think we need more discussion on this, and more clarification.
Okay, can we suspend the motion?
You
There's
can
no
vote
motion.
to table this
then
item if you'd
let's-
like.
Let's vote on the motion to table this agenda item number 3.
Need a
Do we
motion?
even,
Can I make a
You
motion?
can make a motion.
yeah, there's no
Okay,
motion.
I make a motion to table agenda item number 3. Does anyone second that motion?
I second.
Sachi seconds the motion. Are there any additional comments from board members?
Maybe I should save it for after, about what we expect back in terms of our when we are visiting. Yeah, when we can reconvene. I mean, should I discuss that now, or should I wait until after the motion has been decided upon? Okay, I just want to make sure that we're clear in our direction as to what we expect reported back to us the next time that this is considered, because the CPC has considered this and has sent it to us for our commentary, and I think we should, really fully report back to them why we're not making a decision now and what information we would need to make a decision. And part of that conversation, part of that discussion, I would like to include this discussion about the responsibility of the administrative law judge, and about this concern as to the this concern about the opinions that come from administrative law judges. I don't want to make judgment about it, but that is part of what we expect to have a discussion about, a reported discussion about.
Let's take this a step at a time. Let's first vote on the agenda item that we want to table until a future meeting. And then go forward from there with what we would like to see in a revised motion, and that probably ought to start with the CPC, since they're the ones that originated the motion and sent it over to us.
Oh, so you want to send something back to them to consider?
Well, that was what Carrie Ann said a moment ago, that what we send back to the CPC would give a full discussion to the conversation that took place here.
No, not the I don't think that comes from the CPC. I think that comes from the from staff. Yeah, staff is going to. We're just reporting to the CPC that we have tabled it because of these concerns, and that we're awaiting a report from staff on the concerns that we've expressed. And then the CPC can decide whether or not they also want to take that into consideration in making their, part of their process. But for us, the report is from the staff, not from the CPC.
Thank you for correcting my language. That's what I meant to say, and that we're taking our recommendations, though, and sending it over to the CPC for their comments. So
Yeah,
I think
it's merely a report.
their report. Okay, let's vote. So I will make a motion, which I think I did, but
Yeah.
I'll repeat it, that we are voting to table agenda item number 3 for the reasons stated and discussed here.
Public comment.
Board member comment, public comment. All right. I will now call, did anyone second my motion?
Yes, so she did.
Okay, very good. I will now call for the vote. Please call the roll.
George Pamela,
Yes.
Carrie Ann Farrell Hines,
Yes.
Soshi Leon,
Yes.
Alicia Burhow,
Yes.
and Kathleen Wright.
Yes, motion carries. Okay, thank you. Got one more item, agenda item, actually 2 more items. Yes, ma'am.
Just, could we get a bit of clarification? I know that part of the dialogue was that in bringing this back, staff would be researching and bringing some items, and I just want to make sure that I understand clearly what those items are. There's one that would be information that I would be brought back from council. We would work with council in doing that regarding concerns on the performance of the ALJs. And then the second, I believe, had to do with narrowing or how broad the issue is and the types of convictions. Are those the 2 areas that the members are wanting us to bring back? And if, are there more, or have I missed any?
On that last point, and I don't want to speak for you, but from my perspective, it was more just understanding if we narrow that, because my original understanding was it was going to be just partly for efficiency, so if it was just going to be drug and alcohol, or were there some other similar types of offenses that we would want to bucket into this lesser, I guess, punishment, what would make sense then, and which ones would we pick if it's anything more than the drugs and alcohol, or are we just limited to that?
Okay.
Maybe some information
So better
on the
defining the
type of
scope,
convictions.
if you will.
And
I'm sorry.
Go ahead.
And around this issue of the administrative law judges, the hypotheticals that you presented, I appreciate that they were presented for, to clarify, but, and, not to be, excessive. But I would be really concerned if an administrative law, I'm very concerned if we have to second guess or review an administrative law judge's decision because they could potentially impose a lesser penalty for a crime that is so obviously egregious that it wouldn't warrant a lesser, that it wouldn't warrant that lesser penalty. So for example, if a licensee were convicted of arson, or manslaughter, and an administrative law judge would see fit to imposing a 1-year, suspension, that's disconcerting about the quality of the administrative law judges that we're getting. That's not a problem with our regulations. And so I just want to be real clear about what our expectation is on the report on the concerns about the administrative law judges. Because if we really do have to be concerned about them fulfilling their responsibilities, then maybe as a body we need to take up sending a report or a request or, having some kind of investigation as to the administrative law judges, pool, or I don't know how we would go about addressing that, but that would be really disconcerting if we have administrative law judges that are, not taking into consideration adequately the severity of the underlying crime that a licensee has committed. I find that really disconcerting.
Let me add one further comment to it. What I would like to see back in order to make a decision on this is the process as it currently exists, which has the minimum, at least on this item, the minimum of 3 years of probation. Christy, what you pointed out a moment ago was that the board does have the flexibility as we speak to lower that 3 years to something less, if that's the case. So I'm not sure that I understand and discern the difference between the responsibility that's on the board right now and the responsibility that would be on the board if we went to a minimum of 1 year. I'm not sure I see that there's a difference because we currently have that responsibility, so to speak. And if we do have that responsibility and we're not actually spending an appropriate amount of time evaluating the decision of the administrative law judge, then what I would request would be that staff in their summary of the case provide a separate heading for the remedy and evaluate whether or not it's appropriate and in line with our guidelines in the offense and so forth, so that it's more... the information is reviewed not only by staff, who's more closely connected to the case, but then also highlighted for our review.
Yeah, the staff can't do that because they're not allowed to participate in the deliberations on a proposed decision by law. That's something that I provide you, so I'll make sure that any information that's provided is included that every time. But we can talk about that at a later date. But I just wanted to address the question that you raised. Under the Administrative Procedure Act, there's about 5 options for dealing with a contested case, and that's a case that goes before an administrative law judge. And when you want to increase the penalty, the only option is to reject the decision, order the transcripts, order argument, and set it for another board meeting. So it extends the time frame for you to be able to prosecute your cases. It adds 3 to 6 months to the process of prosecuting a case. And so that is why it's much harder to revise a decision when the penalty needs to go up versus when you want it to go down, because the law allows you to adopt a decision and lower the penalty without changing the substance of the body of the decision. So decisions where the penalty is too high can still be prosecuted quicker than those where the penalty is too low.
Okay.
And that's why there's a distinction and a difference between where you are now and where you would be going if you lowered it to a 1-year penalty.
Okay, and Christy, thank you for that clarification, but it would be my response that the issue that we're supposed to be questioning or dealing with is an issue of the appropriateness of the penalty. It is not an issue as to whether or not procedurally it's quicker to go this way or that way or whatever.
The only reason I raised it was because efficiency was raised as the reason why we're going to the 1 year. And that's why I'm explaining that it would be more efficient to keep it at a higher number if you were concerned about being able to lower penalties at will.
Well,
But if that's not your main concern, then,
If it's procedural efficiency with respect to one decision or another, then my response to that would be, let's look at the procedure and let's change or modify the procedure as opposed to incorporating penalties that are not appropriate to the offense.
correct.
Okay. We voted, we tabled, and Patty asked for clarification. Are we all happy? All right, very good. Agenda item number 4 is a discussion and input regarding the newly developed California Board of Accountancy Enforcement Handbook for Licensees. And Dominic's going to tell us a little bit about that.
Yes,
Thank you, Dominic.
So this agenda item is being provided to give the CBA the opportunity to review and provide feedback on the newly developed Enforcement Handbook for Licensees. There's no specific action required of the CBA on this item, though staff always value feedback and input from members on the handbook. The CBA has considered numerous enforcement-related topics over the course of this year, and as the CBA has progressed through these discussions, it has expressed its desire to ensure that licensees understand the CBA's enforcement process. So in an effort to address the CBA's request, staff have developed a handbook attached to this agenda item. The 13-page handbook covers 6 main enforcement topics: the processing of complaints, conducting investigations, taking enforcement or formal disciplinary action, probation, and the petition process, and then some important miscellaneous information. Throughout the handbook, staff have attempted to provide licensees with an understanding of what to expect during the enforcement process and exposing licensees with various key terms should the matter proceed to enforcement action, including formal discipline. An important area staff focused on during the drafting of the handbook was providing licensees with an understanding on when to expect communications and what to do when responding. Staff have also focused on providing important information regarding cooperating in investigation and tips for assisting in the investigation. As this document will be placed on the CBA website, staff have included links throughout, and these include links to various business and profession and government code sections, CBA regulations, links to the Office of Administrative Hearings website on what to expect if the matter proceeded to an administrative hearing, email contact and contact information for the Enforcement Division, links to the disciplinary guidelines, and the CBA publication update. Also included in the handbook are 3 specific topics that CBA had discussed at various meetings over the course of the last 2 years. Staff have included specific information regarding the tolling provision and to ensure individuals are aware of this standard term and the condition of probation. Staff have highlighted important information regarding the need to keep a current address of record, and we've included a link on our website to the address change form. And staff have included information regarding bilingual services, both during any contact with the CBA and should the matter proceed to a formal administrative hearing. Again, as I noted before, once this handbook is completed, it will be placed on the CBA website, and staff will prepare an article for increased exposure through the CBA publication update. We have received some feedback from legal counsel, and this will be incorporated into the handbook. Again, while there's no specific action required of the CBA, staff value any input and feedback members have, and I would like to turn discussion back over to Chair, and I'd be happy to answer any questions members may have.
Okay. Does anyone have any comments? Oh, good, Carrie Ann. Yeah, please.
I appreciated seeing the additional information about the explanation about the burden of proof and the rehabilitation evidence, because I know that we discussed that was an important issue. The other issue that we talked about, and I don't recall what the outcome of that conversation was explaining to licensees the way in which the tolling process works. and I'm looking at the explanation, and it doesn't really seem like it's that much clearer to the licensee in just this pamphlet. Now, the burden is on the licensee to really, do their investigation and diligence around understanding what the penalties that are being placed upon them are. But I recall that we do have had a concern about the extent to which licensees understand the operation of the tolling statute and their ability to, attempt to, negotiate the terms of tolling or of a tolling penalty. But though, I just wanted to bring those up in the record, that I noticed them.
So,
Okay, Sachi?
I see it here as well, and I completely agree. If there's just a way to call it out a little bit more prominently, so I had never heard of the term tolling until I came here. So it's not a common buzzword,
Yeah.
let's say. Maybe
So more like
within-
a plain English explanation of what
yeah,
tolling
and
is.
just call it out,
on
really
page 9.
bold it, anything, just call more attention to that, because I think there's a lack of awareness.
And that was my question to you, Carrie Ann, is maybe if that's something we can add to it? I don't know if that's going to kill our timeline.
There's no timeline.
Okay,
We
so
we
it's
do
just-
have a section here on tolling, but I'm
Yeah.
happy to modify the language to better, I guess, layman's term, the language if that's necessary.
Yeah, that would fit.
Oh, I'm sorry, George.
Yeah, and then I just had, I don't know if it's a comment or a question. I didn't notice anything about what the rules are around when they put the result about the licensee on the website, or maybe I missed that. I just kind of feel like that should be something, if somebody's going through this, they would want to know what those rules are, if I'm being subject to discipline, or understand how that's going to, what the results will be, to me as a licensee, but just throwing that out there as a question.
Okay, Dominic, are you okay with that?
Yeah.
Dominic, you okay?
I'm okay with anything
Anything.
the board directs.
All right, I have two comments. One on page 2, where it lists common complaint referrals. My two favorites got left out, IRS and the FTB. So IRS and FTB. And then as a second comment, and I'm willing, Dominic, and from anybody else, to be overruled on this, would it be, and I'm really asking in that context, would it be appropriate to list certain decisions that are illustrative of application of these penalties to practitioners? The reason I say that is because in the area of regulatory review, there's a real focus by CBA that in order to approve a continuing education course, that actual cases involving issues related to regulatory review be included in the course materials. And so I'm not suggesting that you put a complete synopsis of the case in here, but just a reference to a handful of decisions where if the licensee were interested, they could go and take a look at the facts, take a look at the decision, and then come away from the process with a practical application perspective as well. Christy?
So do you think if you could put a link in here for people to look up the public enforcement documents, would that satisfy it? Because that way people could
Yeah,
peruse
sure.
them
Yeah.
as opposed to having staff write a summary of some
No,
cases.
I had no intent of having a summary of the case. I think if you make this thing a textbook, nobody's going to look at it
Right.
anyway. And so just a link wherever you feel it's appropriate to a handful of cases that are well-written, where the facts are fairly common, and then a person could come away with it with some appreciation for real examples. Okay. And we're not voting on this, are we?
Just recommendations.
No action is required, so I don't believe we need to vote. All All right, very good. Agenda item number 5, are there any public comments? Finally, are there any agenda items the members would like to be considered in a future meeting above what we've already discussed? We do have those items recorded, but anything else that you would like to discuss? All right, very good. Thank you so much, and the meeting is adjourned.